This is Professor Porter. The course is called Trial Techniques. We're in Chapter 2, Trial Advocacy Topics Generally, and this is one that motions eliminate, subheading 210. This is one that doesn't fit anywhere else neatly, but motions eliminate are huge for not only trial, but for mock trial for people in it. And essentially, even though I have a separate chapter that's going to be on objections, and motions eliminate are nothing more than written evidentiary objections that are often pretrial. It's important to think about it in the same chapter where I'm talking about case analysis and case theory and prioritizing good facts and bad facts, that type of thing. Motions eliminate is a way of critically evaluating your case presentation with an evidentiary lens. Absolutely, for me as an evidence professor, understanding the rules, knowing how the rules work, motions eliminate are a tool. The rules of evidence are a tool and a skill that can be developed. And there's one reason above and beyond experience that someone like me would be able to essentially cause a lot of problems for someone that's new to trial. And that's because I know the rules, I know how the rules work, and I can use those rules to critically evaluate my own case, but most importantly, evaluate my opponent's case such that I can file motions eliminate and object to trial and respond to objections at trial where the rules of evidence can work out in my favor and work out to my advantage. So one of the things I do is when it gets close to trial and by often a deadline imposed by the court for motions eliminate, I'll look at my opponent's case, I'll look at key evidence, I'll have these meet and confers, I'll have these meetings and try to get into, what do you intend to do at trial with respect to certain evidence, and I might file motions, and those motions are essentially written evidentiary objections, again, almost always pre-trial, although they can be offered at any time, and they can be offered orally, after trial or during time when the jury is not present. But what we're really talking about is writing down, offering some additional thoughts, offering the court time where they can reflect and think about it, and making these written objections on points that counsel can agree. So you have the chance of organizing your thoughts, thinking about it with an evidentiary lens, and potentially impacting the case. The opponent's case. I can stop evidence from coming in that was central and something they plan to be part of their case presentation. I can essentially shut down avenues of impeachment where they're going after my witnesses that are not allowed under the rules, and it affects what they're able to do and the credibility arguments that they hope to make in closing arguments. So I'm affecting the shape of their trial. I'm affecting what they might be able to say in closing before the case even starts by hopefully getting some favorable rulings in motions eliminate. The other thing that I do for the court, oftentimes people question the value of motions eliminate because courts don't rule on them. I'm going to, defer judgment at this time because I want to see how the evidence comes in. It's important nonetheless because you're forecasting the evidentiary issues that are at issue at trial. I can, object during trial, ask for a sidebar, go over to sidebar and say, Your Honor, this is the exact issue that we briefed. This is the exact issue that we talked about. Under the hearsay rules, under character evidence, under improper impeachment, under Article 6, I'm isolating. I've already given you a brief. We've already talked about this, even though you didn't rule. It's a head start for the court. It's highlighting for the court, and it's really, an opportunity to underscore some of those key evidentiary issues that you think are going to be impactful in your case. And lastly, because evidence understanding and our knowledge of evidence is a tool and a skill that's part of trial advocacy, I think as early as motions eliminate, I can demonstrate that, hey, I am someone, I can demonstrate to the court that as an advocate, I'm someone that understands the rules, that have looked at this case and with an intimate knowledge of the facts of this case, I've looked at it, through an evidentiary lens. And I can tell you how I think the evidence is going to shake up, and I'm going to make arguments along those lines. And to the court, I'm someone that you can trust throughout trial. That when I'm objecting or when I'm responding to objections, that I've thought about these issues and I've planned for these issues, and I'm someone who knows the rules and whose arguments you can trust. So motions eliminate are a key tool to demonstrate our understanding and knowledge of the way the rules of evidence work.